If something were to happen to you this week, would your family know what to do? And I'm not talking about emotionally, I'm talking about legally. Would your family know what to do to access your house, to make sure that your mortgage continues to be paid? Would your family know how to access your bank account? If you have minor children, if you have someone that you're caring for, an adult with a disability, would your family know how to make sure that there's someone in charge to make sure that that child continues to be taken care of in the way that you would want it to be done? I'm asking you this because I think a lot of people, when they really think about it, they really wouldn't know what to do. If you don't create an estate plan, you don't get to have a say in what happens with your assets after you die. But I'm just saying, there is a process that even if you do not have a will and even if you do not have a trust, there is a process that your family can go through to make sure that your assets get to the right people, to make sure that the right person is in charge of your estate. And that process is the probate court process. And I know that there's a lot of stuff online that people have negative things to say about probate. There's a lot of people saying do everything you can to avoid probate court. And I say, hey, if you're living and you get to plan for that, please do everything you can to avoid probate court if that's going to make sense for your family. But after a person dies, you really can't avoid probate court if that person owned property. And in that event, you need to go through the probate court process because that's going to put somebody that has the legal authority, the proper legal authority in charge of the estate and make sure that things are taken care of. So what I wanted to do today is talk a little bit about the Georgia probate process. I want to make sure that we take all of the cloud and the mystique away from it and just show it for what it is, so that if you or a loved one has to go through this process, it's not scary. It's not something that people feel that they have to avoid. So first, we're going to talk about what is probate court, what's the purpose of it. Probate court basically is like the court where if there is a person who needs someone to be responsible for them, whether it's an estate administrator or a guardian or a conservator, probate court is the place that people go to get someone appointed to take care of the needs of someone who may be more vulnerable or an unrepresented estate. So when someone dies and they own property, that property is in their name. And I'm talking about house, land, other commercial properties. I'm talking about bank accounts, anything that a person has in their name at the time of their death, that is going to be a probate asset. So I'm going to just kind of walk you through what that process looks like. First, you're going to file a petition to probate. If there is a will involved, you're going to file a petition to probate will in solemn form or common form. These days, I don't even deal with common form. I always will go to filing a will for probate in solemn form. Common form is when you may not be able to notify all the heirs. There might be some reason that you need to move a little quicker without going through the typical notice processes. I try to avoid that. I have not filed common form in all my 16 years of practice. I have not done common form, and I hope I don't have to, but it is there. But you file that petition to probate will in solemn form. The purpose of that is if someone has a will, you're going to ask the court to appoint the person who's named as the executor, who's nominated as the executor in that will. You're asking the court to appoint them as the executor of that estate. If a person does not have a will, you will file a petition for letters of administration. And I'm saying this, generally speaking, there are other petitions that we could file, and those are for different reasons. I'm not going to get into those today because that would make this video way too long. So in a typical case, we are filing a petition for letters of administration. In that petition, we are saying, hey, judge, this person has died. You're going to name where they died, the county they died, their address, and details like that. And you're saying this person died without a will. They died intestate. In that petition, you're going to name the heirs at law of that person. And those are the people who, at the time of their death, are their heirs according to state law. So for Georgia, we're looking at the Georgia laws of intestate succession. And you're going to use that to determine who that person's heirs are at the time of their death. You list those people in there. And then you have to make sure that those individuals get notified of the fact that you're filing this petition for letters of administration and you're asking the court to appoint you as the administrator of this estate. you have to notify all of the heirs to make sure everything's done right. Because if you don't have to notify people, then you might do some things behind the scenes that are not the right thing to do. So we want to notify the heirs at law, to notify them that this process is happening. And that's the same, even if a person has a will, you have to notify the heirs at law, even if their heirs are not named in the will. So y'all can imagine what kind of problems that could cause, but that's another video. In fact, I have done a video where I talked about that. We will try to link that in the description so that you can have access to that previous video. But you would notify the heirs, make sure that they have plenty of time to respond to the petition. If they feel as if you're not the right person to serve in this role, or they have some objection to the process, they have an opportunity to file an objection. And if the heirs do not file an objection, or if they acknowledge that they've consented to the petition, then the court will proceed with the process of getting the person who's asked to be the administrator or the executor of the estate to get them appointed. There are some situations that would require the court to publish in the newspaper, to notify the world through the newspaper that this person is asking to be the administrator of this other person's estate. And again, this is to make sure that one thing you got to make sure the person's actually deceased. That you might file something in the newspaper and the person's like, hold on, wait, I'm not dead, I'm right here. Like, please don't administer my estate, I'm actually alive right now. So it gives everybody a chance who may have an issue with the process to be notified so that they can file an objection if there is an objection. Go through the process, get your administrator appointed. From that point on, the person who's been appointed as the administrator or who has been appointed as the executor of the estate, they have the legal authority to manage that estate. If the person, it's either way really, whether the person died without a will or they had a will, sometimes they will get all of the powers of a personal representative, or their powers may be limited. If their powers is, again, this is something that I'm not going to go into great detail on, but you do want to make sure that you ask the court for the powers that you need in order to administer the estate, and there are forms that show you how to do that. Still advise you to get a lawyer, because there's some nuances to this that we want to try to work through with someone who knows what they're doing. Just generally speaking, there are certain powers that are going to be given to the administrator or the executor automatically. There are others where if there's a will, the will had to provide those powers. And if there was not a will, then you have to request those powers from the court, and the heirs have to agree to you getting those additional powers. So that's something to keep in mind. Once the person is appointed by the probate court to be the executor or to be the administrator of the estate, the general term for both of those is going to be personal representative. Once the personal representative is appointed, their job is to put a notice to debtors and creditors in the newspaper. Now I know y'all gonna say, but didn't we already put it in the newspaper? Yes, we did. But now we're putting it in the newspaper for a different purpose. We are saying, hey guys, hey world, I have been appointed as the executor or the administrator of this estate. I am now saying that if you owe this estate any money, or if this estate owes you any money, this is your opportunity to notify us of that so that we can settle that issue. Now, I will say in all my 16 years of practicing law, I have not seen where a person who owed an estate money wrote and said, hey, I owe y'all some money, I'm ready to pay you. I have not seen that. When that happens, it'd be nice to see that for my clients. I know we'll be excited. Have not seen that yet, but I have seen plenty of people who the estate owes money to, where they're saying, hey, we want to be paid our money. So the creditors have a certain amount of time to notify the executor or the administrator of the fact that the deceased person owed the money, and now they are making a claim against us. You have to run that notice in the newspaper for 4 weeks, and then the creditors have up to 90 days after that to file a notice of claim against the estate. If they don't file their notice within that 90-day timeline, it's not like they're going to lose the right to file their notice. However, if the administrator or the executor has given away all the assets to the heirs of the estate, or they've paid other creditors off, the creditors who came in later, they're going to miss out on their opportunity, because if all the money's gone and that time period has passed and they just don't get their money. So the executor or the administrator's job, that one of their first duties is to publish in the newspaper. And they also are looking to see, is there anything that they need to know about concerning this estate? They're doing an inventory to see what did the deceased person own at the time of their death. Sometimes the court requires that you file an inventory, and that inventory is going to have to be filed within 6 months of the administrator or the executor being appointed to the role of personal representative by the probate court. They have to file an inventory within that 6-month period. Once that 6-month period is over, you're doing your job as the administrator. Your goal is to settle the estate as expeditiously as possible. So this means that we're not going to be administrator or executor for the rest of our lives. And I'm saying this because I have seen it where people have been the executor or the administrator of an estate for 20, 30 years, and they thought it was something they're supposed to do until they died. And that's just not the case. Your job is to be appointed and try to get this estate settled as quickly as you possibly can. So once the estate is distributed to the heirs or to the beneficiaries of the will, then the executor or the administrator's job is complete. And in many cases, it makes sense for them to file a petition for discharge. Some cases, it's not needed to file a petition for discharge. That's something that you will talk to your attorney about. This whole process that I described, it takes at least 6 months, because y'all heard me say after you're appointed, you got to file in the newspaper for publishing the newspaper for 4 weeks and then give another 90 days. That's 4 months off the jump. And there's also a period between when you file the petition and when the court appoints you. So you really are at 5 or 6 months just before you're able to distribute any of the assets. Then there's an additional time period where you might be settling things with creditors. You may be selling property. You may be settling lawsuits. There's all kinds of stuff that could be happening that would drag the time frame out to be a longer period of time. And so you can imagine how going through the probate process can delay when the heirs or the beneficiaries receive their property. A few things I want to point out about this process. One is that it's very public. It is a public process. You file the will in public, you file a petition in public. Once it's in that probate court, it is a public record that anyone can look at. Another thing that I want to point out is that the executor or the administrator's job is to keep the heirs or the beneficiaries informed about the process, to make sure they know what's going on and that they're not getting lost as the process is going on. So they need to keep everyone reasonably informed about what's going on. Once the process is done, the executor or the administrator can now distribute the assets to the heirs or the beneficiaries. I also want to point out the fact that a lot of times when we're dealing with heirs property, people think I can handle the heirs property with one probate case. You may have to file multiple probate cases in order to deal with heirs property, because a person may have died several years ago and their heirs or some of their heirs may have also died. So in that event, you're going to, in some cases, have to probate each of the estates of those deceased heirs. There's sometimes some situations where you can file an affidavit of descent, but you really need to talk to an attorney to find out what scenario you're dealing with when it comes to each deceased heir. I hope that y'all found this video helpful, in which I reviewed the probate court process. If you have questions or need to know more, I invite you to share those questions in the comments and let me know. I also want to let y'all know that I have a webinar coming up, a live webinar where I will be talking more about estate planning, heirs property, and probate. I invite you to join me on May 24th at 5:30 p.m. Eastern Time. Until then, y'all take care. This is attorney Veronica McClendon. Look forward to talking to y'all again soon.